So if you are on the Zoom feed, please mute yourself. I'm not quite sure who all these folks are unless they are attorneys or parties. Generally, the Zoom link is just supposed to be shared amongst counsel. But I'm going to need to remove from the Zoom feed anyone whose phone or connection makes noise that is distracting to the court reporter, who I think is virtual or very, very small. Who's the court reporter?
Melissa Chatham, sir.
Hey, Miss Chatham, how are you?
I'm good, thank you.
Will you let me know by becoming verbal or doing something if you are unable to hear any of the lawyers here in court, or me, also a lawyer in court? Okay.
Yes, sir.
All right. Thank you for covering this.
Yes, sir.
Well, let's get on the record. This is 2022 CV 367796. It's SisterSong Women of Color Reproductive Justice Collective and a whole bunch of other plaintiffs against the state of Georgia. I'm going to get the appearances for the two sides in a moment, but I just want to lay a little bit of groundwork. We are here in courtroom 8D. The courtroom has got a few folks in it. It's important that people here maintain some semblance of decorum. If things are said that frustrate you or with which you disagree, register that internally. When you're outside the courthouse, you can yell or paint a sign or do something. But while we're here in 8D, we will listen respectfully to what one side has to say and then what the other side has to say. Similarly, with the Zoom feed, again, if there is anything that becomes distracting, I'll have to remove you from the Zoom feed, and you will need to watch the live feed over YouTube. This is very, very publicly accessible. Courtroom 8D is open, and there's actually room on some of the pews, but otherwise there is a live feed over YouTube right now. Second, masks. If you are going to be routinely speaking, you're welcome to remove your mask. That's why my mask is off, so you don't have to keep putting it on and taking it off or have a mumbled objection or concern. Again, if you will be addressing some of what we're going to cover today, you're welcome to remove your mask.
Great, for Friday. I can call them and tell them it will be.
Hey, Jessica Moyer, I'm going to remove you from the call if you don't mute, okay? Awkward moment. All right. Finally, I just learned Olivia Newton-John passed away. So if you're a big fan of Grease, moment of silence for ONJ. Let's get started. If I could please have the entry. I don't need to know everyone who's here for all the plaintiffs, but the folks who will be speaking, the court reporter has actually asked in the chat. Real important for her to know if certain people are going to be getting up. And I don't mind tag teaming. I do mind like 3 people talking at once, but as many of the lawyers on plaintiff side as you deem necessary can speak. We just need to know who that's going to be so that the court reporter can reflect that. And we'll do the same for defendants as well, although I'll note there are only 3 people at that table. So on behalf of plaintiffs, who do we have and who is going to be talking today?
Good afternoon.
Oh, and one last thing. I'm sorry. I interrupted you. I think we will largely be focused today because it's 4:02 and ominous rumblings outside. I got nervous about this hearing without it, but thunder and lightning just before we started. We'll be primarily focusing today on sovereign immunity and void ab initio. If we've got time, we can dive into the different factors to be considered about a TRO and ultimately the questions about due process rights under the Georgia Constitution, et cetera. But I think we're going to be time constrained. And so we will likely, for sure, I want to cover sovereign immunity, soup to nuts. I want to turn next to void ab initio. If there's time after that, we can pivot in whatever direction plaintiffs want, and I'll certainly give the defendant a chance to respond to anything and everything they hear. But that might affect like, oh, no, I don't get to say anything today because we might not get to the difference between the 6-week rule and the 22-week rule. That may not fit in the time constraints we have today. That doesn't mean we'll never talk about it. It just may not be something we are able to get into today. So I won't interrupt again. Sorry.
Well, good afternoon, Your Honor. That was a helpful
for our ordering of argument today. So appreciate those guide folks. I'm Julia Stone from Kaplan Cobb here in Atlanta. I am joined by my co-counsel, Julia Kay from the ACLU, and Tiana Mickelvet from the Bondurant firm, also here in Atlanta. I will be handling the sovereign immunity portion of the argument.
Busy day for you.
Yes, and Ms. Kay will be handling the void ab initio and the other substantive pieces of the argument.
Okay. And there is one lawyer on the plaintiff side whose pro hoc made it all the way through, and I signed that today. Hence presence at the front seat.
Thank you, Your Honor.
All right, and just full disclosure in case folks are digging deep into my past, even though I have nothing to do with this other than trying to resolve this based on good arguments on both sides. I think Ms. Mickelvelt and I may know each other. Did you have kids who played baseball?
THYS, Your Honor, that's correct.
Yeah, so we met long ago. Your husband may have been like an assistant coach with me or something like that, because I recognize the name. I definitely recognize the face. I don't remember if her son was good or bad at baseball. Mine is great. But I don't think there's any issue there, but I'll let the Solicitor General's office, if they decide later on, that's a conflict. They can bubble that up. I don't think it is, but I've been surprised at what the media dredges up about people involved with cases like this or a special purpose grand jury. So with that, is there anyone else, Ms. Stone, you think we may be hearing from, just so the court reporter doesn't panic and say, I don't recognize the other lady in the row?
Assuming nothing goes completely off the rails, it will just be us speaking today.
Okay, got it. And for the state of Georgia.
Yeah, thank you, Your Honor. Stephen Petrani for the state of Georgia. I'll be doing, I think, all of the speaking today. I also have Drew Waldbieser, a Deputy Solicitor General with me, and Hannah Basta, an Assistant Attorney General, but I think it's just going to be me talking.
You don't share as well as the other side,
I
apparently.
mean, if they want to take it all, they can, but I think I'll bear that load.
All right, and it's pronounced Petrani.
Petrani.
Petrani. Great. Thank you, sir. All right. Then why don't we get started? And again, Ms. Stone and Ms. Kay, I'm not trying to, I'm trying to frame things because I think there is a certain manner that I need to work through things. And I think sorting out what the legislature waived on behalf of the state is step one. And I guess I should add this. I have done my best to absorb everything that was presented in the pleadings. I can't promise that I read all of the attachments. When I mentioned to plaintiffs that they could, I'm going to remove Mike Ox Big. I bet he has nothing to do officially by Mike Ox Big. Okay. The reply brief today was 414 pages long. I didn't have 414 pages of time. I read the 20 pages. I didn't read what's the name of the doctor who got gored down in Florida?
Yes, Your Honor, this is defendant's witness, Dr. Ingrid Scott.
Scott. I didn't read everything about Dr. Scott. But I have done my best to get through all the briefs. And so I have a flavor of where both sides are going with this. They were very well written. Thank you for the work you've done. I know that in particular for Mr. Petrani and his team, it's been on a compressed schedule. Not that plaintiffs haven't been working hard, but you have for a number of years been challenging the Life Act. And so I got the sense that some of the concerns you raised, you were able to pluck from pleadings that you've worked very hard on, but for many months. Mr. Petrani and his team were reacting on short notice, but I appreciate that. And the reply brief was quick turnaround as well. So I don't mean by anything I'm saying today that we don't need to get to what is at the heart of the issue, which is the right to reproductive freedom for women in the state of Georgia. That's out there. I'm not dodging that or avoiding it, but there are procedural hoops we need to get this process through before we necessarily get to the heart of the issue that everyone is here to discuss. So.
I'm on a Zoom call, honey.
It's going to be an interesting afternoon. Everyone be patient. I can't shut Zoom down because our court reporter is on Zoom, but that link seems to be circulating. So Ms. Stone, I'm going to ask you to start since you've identified as the sovereign immunity person. And Mr. Petrani, we will break it up by topic, meaning after Ms. Stone has shared what she wants to share about sovereign immunity, I won't then hear from Ms. Kay about the void ab initio, but I'll turn to you and hear the state's perspective on the sovereign immunity question. Let me just frame it up as I understand it. No one is debating that because of the constitutional amendment that was passed a couple of years ago in response to some Supreme Court opinions that said, yeah, actually, you can't sue to challenge the constitutionality of a law in Georgia. The Constitution was amended and it allows a litigant to bring a civil action seeking a declaratory judgment that a particular statutory enactment is unconstitutional. The state doesn't contest that interpretation of it. As I understand it, the main disagreement is, can an aggrieved litigant seek temporary injunctive relief before the declaratory judgment is received? And there is some language in—
Yo, free my nigga, bruh. Free my nigga.
Court reporter here. I can't hear. I suddenly can't hear anybody.
Yeah, me neither.
Court
I
reporter, we
think
can hear
that
you.
they have a problem. I think they have a problem.
Court reporter, we can hear you.
We cannot hear anyone. Sorry.
We can hear court reporter. We cannot hear the courtroom.
Yeah. I'm sorry, reporter. Can you hear them now? Can anyone hear me? Hello.
Yep, we can hear you. Audio's back. Everyone should mute. The Zoom session has been locked, so if you are removed, you will never get back in. So keep that in mind. Keep your phones muted. All right. Court reporter, sorry about that. In an effort to quiet a few folks, the podium microphone got muted, and that's the one through which all sound travels in the courtroom. So you should be, can you hear us now? Thumbs up. There we go. Great. So anyway, I was framing the issue as I understood it. Yes, declaratory judgment relief is available for someone challenging the constitutionality of a legislative enactment. The discussion that I think we need to have is it limited to maybe you get it, and if you do, then you can get injunctive relief? Or are all of the toolkit that is available to someone seeking declaratory relief outside the context of challenging the constitutionality of a statutory enactment available. A TRO, a preliminary injunction, and other forms of relief that could be sought if this were a declaratory action concerning the interpretation of a contract or something like that. And plaintiffs believe that that repertoire of tools is available to them, and that would include the TRO that is the subject of their emergency motion. The Solicitor General has pointed to the plain language of the constitutional amendment, so the Constitution now, that suggests that, doesn't suggest, the language is injunctive relief is available after declaratory relief has been provided, if it is. And in the reply brief this morning, I understand that plaintiffs have pointed out, well, that would be the permanent injunctive relief that would flow naturally from a finding that the statute
shut the fuck up.
is constitutional. So Nick is going, in case anyone was wondering, that was Nick, and he'll go away now. And if I learn he's associated with either side, I won't hold that personally against either side. I don't see Nick on there anymore. Okay. So Ms. Stone, with that
I think
context.
he left.
Thank you, Your Honor. And I do want to say we didn't share the Zoom link outside of this group and our clients, and I'm not accusing the state of doing it either. I think it was on the Rule NICI, so that was publicly filed.
Thank you. I was just talking with another judge about that, who handling something of a different level of interest for the media, but nonetheless, because it was on the Rule NICI, people are like, hey, I know how to get on in there. So we'll handle that differently in the future.
So
All right.
I think Your Honor is honed in on the precise issue that we're here talking about today. And I want to start with your first general point that the state doesn't appear to be contesting that sovereign immunity has been waived for this action at large. And that's Article 1, Section 2, Paragraph 5B1 of the Georgia Constitution. And as we read that paragraph of the Constitution, it actually contains two separate waivers of sovereign immunity that cover each of the two claims that plaintiffs have brought here. So the first sentence waives sovereign immunity for actions seeking declaratory relief that acts of the state violate the Constitution. That's our count one for a declaratory judgment. Second sentence waives sovereign immunity so that a court, after entering declaratory relief, can issue an injunction to enforce its judgment. An injunction to enforce a judgment is necessarily a permanent injunction. That's count two. So the state, again, appears to concede we can bring this case, but they say, well, no, you can't get temporary restraining order or preliminary injunction. The court doesn't have the power to hear this type of motion. And we think that's a plain misreading of the Constitution, because the waiver of sovereign immunity for declaratory judgment actions, which is the language of the Constitution, necessarily encompasses all of the interim relief available in those actions. And the Georgia Supreme Court has made that clear. It's held that when sovereign immunity is waived for an action, sovereign immunity is waived for all types of relief in that action, unless it is specifically excluded from the waiver of sovereign immunity.
So this would be your couch argument and attorney's fees or something like that.
Precisely. And I think couch is directly on point. And in that case, which is an opinion written by Justice Namias, Supreme Court really focused on the word action in the waiver of sovereign immunity. And they said that when the legislature uses the word action, it, quote, indicates that such cases proceed under the usual rules of practice and procedure applicable to those actions. And unless it's specifically excluded from the waiver of sovereign immunity, the waiver includes all the relief. So there, of course, it was the Georgia Tort Claims Act, which waives sovereign immunity for tort actions. And the issue was, can fees available under Rule 68 of the Civil Practice Act be sought in that action? And the court said, well, you don't actually have to explicitly incorporate the provisions of the Civil Practice Act into the waiver of sovereign immunity, because the Civil Practice Act, by its own terms, governs all actions of courts from courts of records in this state. So
that's how I read couch also, but Rule 68 would be 9/11/68, which would be part of the Civil Practice Act. and a temporary injunction, a TRO, or a preliminary injunction, not part of the Civil Practice Act?
It is part of the Civil Practice Act. It's 9/11/65
Okay,
provides for temporary restraining orders and for preliminary.
so it's part of the same family as fees through
Exactly.
68.
It's interim relief, and it's also available under the Declaratory Judgment Act itself, which is 943B, which provides for interim relief in a declaratory judgment.
Okay, well,
act.
that was what I was thinking, was that if you were in chapter 4, that's not chapter 11, but you're saying 65 gets you that.
It's in both.
Okay.
Exactly.
It's everywhere.
It's everywhere. So the declaratory judgment.
Shut the fuck up, please.
Sorry about that. Keep going.
The Declaratory Judgment Act provides for temporary restraining orders and preliminary injunctions in a declaratory judgment action. The Civil Practice Act likewise provides for this interim relief. So the state could have, it's absolutely sure, could have excluded preliminary injunctions and temporary restraining orders from this waiver of sovereign immunity. But the Supreme Court in Couch made it clear that exclusion has to be specific. And there is no language anywhere in paragraph 5 of the Constitution excluding temporary restraining orders or preliminary injunctions. And that's in stark contrast to subparagraph 5B4, where the state did exclude certain remedies and relief available in an action, in a declaratory judgment action. They specifically excluded damages, attorney's fees, and costs of litigation. It says no damages, attorney's fees, or costs of litigation shall be awarded in an action filed pursuant to this paragraph. So of course, we're not seeking fees or damages or cost of litigation in this case, but we are seeking a temporary restraining order and a preliminary injunction because that relief hasn't been excluded. And the failure to mention temporary restraining orders and preliminary injunctions has to be seen as intentional. As Your Honor noted, this is a constitutional amendment that passed in 2020. So it's 6 years after the Couch decision came out. And the Supreme Court made clear that using the word action in a sovereign immunity waiver carries certain meaning with it. And that's exactly the language that was used in paragraph 5. So the state wants to point to the second sentence to exclude the relief we've requested here from the waiver of sovereign immunity. But as I mentioned at the outset, that's a separate waiver. It's an additional waiver of sovereign immunity. It's not an exclusion or a limitation on that first waiver. So on its face, plain language says sovereign immunity is further waived so that a court awarding declaratory relief can only, after awarding declaratory relief, enjoin such acts to enforce its judgment. So we've got two things that show that it's a additional waiver. First, it says further waived. Of course, plain meaning of further is additional, moreover. If it was going to be an exclusion, you'd expect it to say something like, except that sovereign immunity is not waived for a preliminary injunction or a temporary restraining order. Second, as I mentioned at the outset, it says it's waived for injunctions to enforce its judgment. That is a permanent injunction. So, and the purpose, it was necessary to include that separate waiver for a permanent injunction as opposed to a preliminary injunction because those are dealt with in separate provisions of the Georgia Code.
Because there's not interim or temporary equitable relief in the Civil Practice Act. There's not a 9/11/65.1 that allows for permanent injunctive relief. It is outside of that.
It's correct. It's outside of the Civil Practice Act and it's outside of the Declaratory Judgment Act, which only provides for interim relief, not for permanent relief. So that second waiver was necessary to be able to enforce a declaratory judgment that's brought pursuant to this waiver of sovereign immunity. So, and of course, you know, a preliminary injunction is encompassed within a claim. It is not a claim itself. You have to have another substantive claim to be able to seek a TRO or a temporary restraining or a preliminary injunction, excuse me. So, and I think it is really important to note too, to kind of take a step back and why this is so crucial, because the waiver of sovereign immunity was in direct reaction, as you noted, to a case from 2017 where the Georgia Supreme Court said, well, you actually can't sue the state to declare a law unconstitutional. And when the state has passed a law that's unconstitutional, when they are enforcing a law that's unconstitutional, especially one that is causing such immense harm to Georgians across the state, essentially forcing pregnancy and childbirth on them.
It doesn't matter how unconstitutional it is. It would just need to be unconstitutional in the eyes of the litigant. There's not this, you're not arguing that this exceptionally applies because this is really, really unconstitutional. It's a challenge to the constitutionality of an enactment, and you're allowed to seek declaratory relief because of this amendment.
Precisely. It's not just for, issues that attract media attention. It's for all laws that are unconstitutional. And there needs to be a provision to enjoin their enforcement while the case gets decided before a final judgment can be entered. So it's pretty simple matter. Temporary restraining orders, preliminary injunctive relief are available in declaratory judgment acts under Declaratory Judgment Act and under the CPA. Sovereign immunity has been waived for actions seeking declaratory relief, and TROs and preliminary injunctions have not been excluded from that waiver. So the court
Keep going.
The court therefore has the power to enter a preliminary injunction or a TRO in this case. Unless the court has other questions, I'll turn it over to Mr. Traney.
Let me see. No, I think I understand your approach. You plaintiffs referenced in your motion a case out of Fulton County Superior Court, and I didn't see exactly how that fit with what we're working through. If you think it is important that I understand that, this would be a chance to say, hey, here's why what your colleague did should shed some light on why we're right.
Well,
you're right.
The state raised the same argument in that case about preliminary injunctive relief, but there was a separate waiver of sovereign immunity that was at issue in that case for contract actions. But they raised the same argument. They said you can't get a preliminary injunction in this case because you can only get it after final judgment on the declaratory judgment. And Judge Williams rejected that argument and said, no, it waives, when sovereign immunity is waived for an action, it's waived for all relief in that action.
But her case was a contract case?
It was, Your Honor.
Okay. And it's different language in the Constitution about, because contracts aren't unconstitutional. I mean, it's a different waiver.
It was a separate waiver, but the state raised the same argument to say that based on this language in paragraph 5B1, to say that the plaintiffs in that case couldn't get a temporary restraining order or preliminary injunction.
Okay.
And to our knowledge, that's the only case that has dealt with this specific language.
Right. Now, I assume if there was some robust appellate law, both sides would have found it and parsed it in their own direction. So, okay. Thank you. I will circle back to you if I have questions about your position after I hear from Mr. Petrani. So, Mr. Petrani, you may have a more uninterrupted presentation because we've been gradually weeding out the bad participants.
Thank you, Your Honor. I think the plaintiffs have this exactly backwards. First of all, the text is clearly against them, but just to take a step back, they come at this as, well, if there's some ambiguity, we need textual affirmation that this isn't waived. But actually, the rule is that if there's some ambiguity, you don't assume a sovereign immunity waiver. You narrowly construe sovereign immunity waivers. And I want to deal with Couch in this ex contractu case as well. They're dealing with very different waivers that refer specifically to a type of an action and don't limit the remedies at all. One refers to ex contractu actions and one refers to tort actions. So to just...
How does this provision not refer to declaratory judgment actions? It uses the word action.
Yeah, it says, yes, it says actions seeking declaratory relief. And even if, let's just assume for the moment there are two ways of understanding that. That's actions seeking declaratory relief and everything else that happens to be in that action, which is plaintiff's position, or our position, which is it's actions seeking declaratory relief to the extent they're seeking declaratory relief. Otherwise, you wouldn't use this phrase. In plaintiff's estimation, anything you can do in a declaratory judgment action, you can do in this sort of an action, but you can do everything in an action that happens to include a declaratory judgment. And in fact, I think plaintiffs misspoke before. In the Declaratory Judgment Act, it does specifically say, this is section 943, further relief, legal or equitable, including but not limited to damages, injunction, mandamus, quo warranto, et cetera, is available. That's the same place that the declaratory judgment action says that temporary relief is available. It's the very same section. So if that section somehow impliedly brings in temporary relief, then it impliedly brings in literally everything. And no one would write a provision that way. They wouldn't say actions seeking declaratory relief if what they meant was just actions generally. And if there were debate about that, again, because things have to be narrowly construed, I think the state wins. And then on top of that, there's the second sentence in this provision, which is a huge problem for the plaintiffs. They acknowledge that it says sovereign immunity is further waived. So the provision itself is recognizing this is necessary. Without this, you could not get this injunctive relief. And you can only get injunctive relief after you've gotten declaratory relief. But the Declaratory Judgment Act says you can get injunctive relief. So their theory would be that this is pointless. You could already get injunctive relief under their theory.
Does the Declaratory Judgment Act say if you're successful in your action, then through the...
Shut the fuck up! Free my nigga Tyron. He did nothing, bro. Free my nigga, bro. Free him. Shut the fuck up, you bald ass bitch, pussy ass nigga. The fuck you want? The fuck you looking at, nigga? Fuck you. Pussy ass bitch. Fuck all of y'all niggas. Fuck up. Free my nigga Tyron. He did nothing. Pussy, bro. Shut the fuck up. Pussy ass bitch.
So this is coming from our account.
Shut the fuck up. Shut the fuck up, you fucking bald ass bitch. Fuck you, nigga.
Bald. I tried moving Deidre into the waiting room. So not quite sure what's happening. That was the same voice that has infected several of the other folks who dialed in, except this happens to have been someone on my staff. That voice wasn't, so we're clear. I was in the middle of a really important question. I'm understanding your concern, but does the declaratory judgment statutory structure you're referring to incorporate into it permanent injunctive relief, or it's got some of those pre-final results tools like a TRO and damages, et cetera?
It has both, Your Honor. This is section 943. In that section, it includes all further plenary relief, legal or equitable, including but not limited to, and then it lists damages, injunction, mandamus, et cetera. Then separately, it also talks about interlocutory injunctions and temporary restraining orders. So it's all in the same section, but it splits them up. So it's clearly referring to both. There is no reason for this sentence to be in the constitutional provision unless it means what it says, which is you can't get injunctive relief until you've gotten a declaratory judgment. And I would just further point out, the statute itself does not make any distinction about the type of injunctive relief you can't get. It just says only after awarding declaratory relief can the court enjoin such acts. Now, even if there were debate about this, and I think the text is rather clear, but if there was some sort of debate, I think this is where the narrow construction of sovereign immunity waivers has to come in. And I would just like to point out that in these other cases, there was no language like this, nothing even a little bit like this.
When you say other cases, meaning Couch and
Couch
Judge Williams.
These ex contractu cases, there's no language indicating that, first of all, there was no language talking about actions seeking declaratory relief. So there was nothing talking about the specific form of relief we were looking for. And there was definitely nothing that said no injunctions until you get that declaratory relief. And at the end of the day, although I think plaintiffs struggle mightily, they really can't come up with a reason that this sentence would be in here if their reading is correct, because if we're just going to import everything that the Declaratory Judgment Act allows you to do, there would be no need for it.
Well, except that declaratory relief is a judge declares an enactment unconstitutional. If that doesn't stop people from enforcing it in a way that is unconstitutional, or doesn't stop it to continue to be applied, then it's kind of hollow relief. It's academic. Yeah, you were right.
But that's the point, Your Honor. That's why this is included. I think that the legislature recognized that. That's why they have a sentence specifically allowing them, plaintiffs, to get this injunctive order for courts to enforce that judgment through injunctive relief. But they never suggest that there's any other kind of relief available in a declaratory judgment action that should be smuggled through. And if I could just very briefly talk about this sort of, I guess I call it a purposive argument, that there would be some problem if plaintiffs couldn't get preliminary relief. What Lathrop said back in 2017 was that you can't sue the state, but it left the law as it stood that you can sue individuals in their individual capacity. And of course, sovereign immunity doesn't apply there. Now, official immunity does and so forth, but ordinarily, if it's prospective relief, that's not going to be a problem. And so it actually makes a lot more sense what the legislature was trying to do in passing this constitutional amendment is that, look, if you want to invalidate an entire law, okay, let's not do this piecemeal litigation thing. That's fine. You can sue the state and just the state. And in fact, you can't sue individuals. You can only sue the state. That's what we're going to tell you. But that's for a final disposition, a final rule on this for everyone in the entire state of Georgia. If you're looking for immediate emergency relief, it's much more likely, especially since it's going to be a much more ordinarily, when it's properly sought, a much more fact-intensive question as to who is trying to enforce this against me and why. It would make much more sense to sue individuals that are threatening to enforce whatever the unconstitutional thing is and enjoin them, as opposed to the entire state with what should be a rare order. You know, an interlocutory injunction is supposed to be rare. It's not supposed to be given out as a matter of course. And the final point I'll make on that is, again, this provision makes no distinction between permanent and temporary injunctions. But if there were a distinction, it's that permanent injunctions are relatively ordinary. After you win your case, it's pretty much the norm that you get an injunction. Interlocutory injunctions are supposed to be very rare. And even if you have a substantial likelihood of success on the merits, you probably still won't get it unless you can prove some other things. And so it makes very little sense for the provision to specifically say you can't get the ordinary thing until you have declaratory judgment in hand. But we're going to just assume, kind of import this notion that you can get the extraordinary thing before you have this declaratory judgment.
So what is your response to the observation made by Justice Namias that action means not a claim, but a species of claim, and that species carries with it certain trappings, and it might import with it, as it did in Couch, all of the CPA. The word here was action and not claim. Whether that was intentional or not doesn't matter, because that's the word they used. And our Supreme Court has given that some meaning in the context of the discussion we're having. What meaning should let me ask it differently. Why shouldn't I accord the word action the same kind of meaning that it was in Couch?
So I think we're not asking the court to give it a different meaning. We are talking about the action. It's just that it's an action sentence.